Okay, we are moving on to chapter 6 on indoor management rule. Okay, for this topic, you have to recap back what you have learned when you did your business law or commercial law, something relevant to agency. Okay, we're going to talk just a little bit on the agency. And then we're going to discuss the rule in the Quant's case. Okay. Now, what is indoor management rule? Okay, we're going to explain that later. But before we move on to indoor management rule, this is the part where I'm going to ask you to recap back what you have done before on the rule of agency. Okay. So we know separate legal entity theory, whereby a member of a company limited by share, not personally liable in respect of any that is incurred by the company. Okay, and there are circumstances whereby a corporate view will be lifted to see who are the responsible person. Okay, we have seen that when we did our doctrine of separate legal entity, when we did our topics of incorporation, when we look at section 20, section 21, right? We have seen that. Now, but you know, when you did your business law or commercial law, you know that there will be principal and there will be agent. So in our case, the director is the agent. Okay, the principal is the company. So as far as agent is concerned, right, since company cannot act on its own, so he has act through a middle person, which is director. Okay, now as far as the agent is concerned, he has this authority. First one, actual authority. Second one, the second type of authority is what we call apparent or ostensible authority. So what is actual authority? Just to recap, okay, actual authority is basically what is within his actual authority. Okay, so the company is bound by the Agents Act, okay, if he acts within the scope of his actual authority. Okay, now legal relationship with the company as agent created by consensual agreement to which they alone are the parties. So basically, when an agent is being appointed by the principal to act on behalf of the principal, there will be agreement between the director and the company. Okay, and basically whatever powers given, those are the actual authority by the actual authority that a director has. Okay, now under the actual authority itself, we have this express authority and implied authority. So express authority, so maybe in writing or oral. So basically the scope, okay, can be established by applying ordinary principle of construction notice. So basically what is given expressly compared to implied authority, so derived from the position is holding. So basically it can be deduced from the nature of business and according to the practice and usual scope. Okay, so basically as a director, okay, he has this authority to sign checks, to meet customers on behalf of the company. Those are the authority given to the directors. Express authority is very clear cut, but implied authority, there are a lot of cases which you can see. If you look at N12 Private Limited and National General Insurance, this is where the court says that director of company may have implied authority to whatever is reasonably incidental to the conduct of the ordinary business of the company unless proven otherwise. So, and then in another case, in Day and Pullinger Engineering, the court held that the implied authority of a director is to execute the bills of exchange on behalf of the company. Same thing in Chiu Hock San is to receive payments of debts due to the company. And these are the implied authority. Even in Ever Consultant, the director's implied authority is to initiate legal proceedings in the name of a company because the company cannot move. You know, it's a legal persona created under the act, no hands and legs or whatsoever, but they are actually in operation by virtue of the authority derived from the company, given to the director, and the director can actually exercise it. So that's how we run a company. Okay, but bear in mind who are the principal and who are the agent, and basically whatever conduct by that particular agent, in this case director, binds the company. You have seen these rules, okay. There's also other cases which I'm not going to touch into. You can read the notes yourself, okay. Now when it comes to contract, under the provisions of the company, okay, a contract may be made by in writing under common seal, acting on behalf of a company, acting under its authority, express or implied. This is where the powers given to them, okay, to especially to the directors. Or a contract can also be made on behalf of the company orally by any person acting under its authority, express or implied. Okay, see. So section 64 subsection 1 provides how a contract can be made with the companies. Now, any formalities required by the law in the case of contract made by individuals shall apply. So basically, you also have learned what are the requirements for a contract to be legal. Okay, I'm not going to go into that in detail. Okay, the next types of authority is apparent or ostensible authority. So this is where this type of authority is where how does it appear to others? Okay, so basically, if it's a director, you as a commoner, you know that, well, a director can actually sign check. Director can also sign, can also deal with me, right? So basically, apparent or ostensible authority is authority of agent as it appears to others. So basically, this type of apparent authority is based on the concept of estoppel or doctrine of holding out. So basically, to establish estoppel in the case of Freeman and Lockyer, the court says that the party who claims the benefit of it must show that he in fact rely on representation that he alleges. So he rely on the ostensible authority. Okay, so basically an ostensible agent, so in this case director, who purports to act for the company must acting within the scope that would normally be expected to be within the authority of a director. So you know, director can sign check, director can go for meetings, director can actually deal with transactions. So those are what is expected of a directors. Okay, read the case of Freeman and Lockyer yourself, right? And what I'm going to touch about is this. The four conditions when it comes to apparent authority that must be fulfilled to entitle a third party to enforce the contract. So the first condition is that representation that the agent had authority to enter on behalf of the company into a contract. And then such representation was made by a person who had actual authority to manage the business. In this case, of course, the director has the actual authority. And then the contractor, so this case was actually, this condition was based on the case of the Freeman and Lockyer. So in this case, you should know that when we talk about contractor here, it talks about the third party was induced by the director's representation to enter a contract. So basically, if you are dealing with a director, you were somehow or rather induced by whatever representation made by the director. Okay, that is what we call apparent. And then under the MOA or AOA or even the Constitution, the company was not deprived of the capacity to enter into a contract or to delegate authority to enter into a contract. So basically, there's nothing in the Constitution which prohibits the delegation of authority to a director. Okay, these are the four conditions. Okay. Okay, now we have seen the authority by the director. Now we'll have to look at indoor management rule because it relates back to the director's authority. Now this indoor management rule was actually derived from the landmark case of Royal British Bank and Tequans. Short form, most books, they write it there just Tequans case. Now, if you read the facts of the case, this case involving a director who issued a bond to the Royal British Bank. Okay. Now, somehow or other, the articles allows them to do so. Okay, the bond was sealed, and then there was some debt to the bank for the sum of 2,000. Resolution was also passed at the meeting authorizing the directors to borrow on bond. But the resolution did not state the amount. Okay. Now, company claim, because there was no resolution authorizing the amount. So basically, the company was not liable. Okay. One of the defendants' defense, they saying that the directors had exceeded their duty. Yes, there was resolution to borrow on bond, but there was no amount that has been decided. So because of that, the company claimed they are not liable, and they also claimed that the directors had exceeded their authority. Okay, what happened then? Okay, court held, interestingly, court held that the company was liable on bond. Okay, as the requirement for the resolution was a matter of internal regulation of the company. Correct. How would a third party, the bank, knows what is going on in your company? When the third party deals with that particular director, what happened? When the third party deals with that particular director, they actually deal with those authority that the director has. It may be apparent, it may be actual, it depends. And of course, the bank wouldn't know. Why? Because those are within the internal regulation of the company. So basically, the court says that the bank could not know whether such resolution had in fact been passed. They don't know. Okay? They are entitled to presume that resolution had indeed been passed. So, when the director meet the bank to borrow, the bank is entitled to presume. They can have this presumption that that particular director who came and see them had the authority to enter into a contract. That is what meant by presumption of legality. Now, okay, when we talk about presumption of legality, okay, so case of Morris Canson said that it is a rule of business convenience. The court says that the will for the is a rules of business convenience, for the wheel of business will not go smoothly round unless you assume that it is in order, which appears to be in order. So let's say a director who comes and see you, right? You are at the bank. Okay, would you ask from detail? Would you ask every little detail from the director that where's the authority? Was there any meetings? What sort of resolution was made? Basically, the bank would not have asked this. Okay, now court says that the bank can presume that all those internal regulation has been done. Okay, so because of that, we have this in-law management rule, okay, what we call presumption of legality, or this particular presumption is actually based on this maxim. I don't really know how to pronounce it, but I can just try. Maxim omnia presumuntur rat et solemnite esse acta. There's also sound very difficult, or known as presumption of legality. Okay, so the rule operates essentially as an evidential presumption of regularity. So basically, when the bank presume all those regulation has been complied, they would not have asked. However, bear in mind, this is not an absolute and unqualified rule. It only applicable in certain circumstances. You cannot just simply say it's applicable everything. No, because it's not absolute.